This is Colin O'Keefe for LXBN TV. In the first of two scandals surrounding the National Security Agency this week, a report by The Guardian revealed that the NSA had obtained phone records from all Verizon customers over a 3-month span. Joining me now to explain how something like this could happen and what's ahead is Andrew Hinkes, attorney with Berger, Singerman, and author on the firm's blog, The E-Discovery Reporter. Andrew, first, we should all by now know the basics of this, but what are the details here? Who ordered this, and more importantly, what judge approved it?
Well, Colin, the Verizon order that's now been widely distributed was entered by Judge Vinson from the Federal Court for the Northern District of Florida. This order was entered in Judge Vinson's capacity not as a sitting district court judge, but as a judge for the U.S. Foreign Intelligence Surveillance Court. Now, this is a court that was established by an act of Congress called the Foreign Intelligence Surveillance Act of 1978, and it's been an active court since 1979. This is a court that's made of 11 active federal court judges who are chosen by the Chief Justice of the U.S. Supreme Court to serve 7-year terms. The purpose of this court is to allow for applications and the granting of orders permitting electronic surveillance anywhere in the United States, and that is within the United States. The records of this court are kept confidential, and they're kept under seal, not to be released for 25 years. Now, this isn't like a trial court where there are two parties that are arguing their position in a case and hoping that the judge is going to side with them over the other guy. This is more like a grand jury, where a prosecutor, in this case the U.S. federal government, wants the court to okay the issuance of what's called a FISA warrant. And this is a warrant that gives the government the okay to conduct domestic electronic surveillance. So in this court, the only party that's going to appear is the U.S. federal government. So like I said, this court's job is to review applications by the U.S. government for surveillance and to determine whether the application is sufficient to show that there is essentially an emergency that requires domestic electronic surveillance. They have to show that it's intended to target a foreign power or an agent of a foreign power. They have to explain what the information sought is, and they have to explain the type of the activity which will be subject to the surveillance. Now, notably, this isn't something that typically will allow the government to just run roughshod. What the showings they have to make is something called minimization, which requires the government to demonstrate that they're using a method to gather the information that sweeps in as little unnecessary information as possible.
I see. So second, what's next here? Obviously, a number of Americans are upset, particularly Verizon customers who had their records obtained by the NSA. But is it possible for those Verizon customers to challenge this or prevent something like this from happening in the future?
Well, Colin, there's been a lot of media attention given to this, and I think that Verizon customers and American cell phone users at large should remember that this is a limited order. They are not capturing the content of conversations. What they're capturing is what's referred to as metadata, or the data about the data with respect to conversations. They're capturing which device or what phone made the call, where the device was physically located, when the call was made, and to which number the call was being connected. So it's not they're not capturing the content of the conversations, just information about the conversation. Secondly, as your first question pointed out, this is limited in its scope. It's only for about 2.5 to 3 months. And thirdly, this one was entered by a court. It went through the procedures I outlined in my answer to my previous question, whereas under the Bush administration, domestic surveillance was conducted without the purview of a court at all. Now, there's been a lot of calls for challenging this order. Recently, in February, the U.S. Supreme Court entered an opinion in a case called Clapper versus Amnesty International that set a very, very high bar to these types of challenges. And what the court said in Clapper was to challenge a FISA warrant, a party would have to show that it sustained actual injury, actual harm, and that the damage to that person was caused by the monitoring conducted pursuant to a FISA warrant, as opposed to any other kind of wiretap or surveillance. Now, because this is a secret court, and because its proceedings are kept confidential and under seal for 25 years, it was presumed when the Clapper opinion came out that no one would ever be able to challenge this. However, in this case, as the Verizon order was actually leaked, there seems to be a way around the Clapper test. However, even if a party did get past the Clapper test, they would likely be hard-pressed to establish that there were actual damages, because it's really hard to say how the government, knowing what phone number you called, caused you damages. And even if you could assert a cause of action that included a proper pleading of damages, you would still have to take discovery from the government, which the government would likely invoke something called the state secrets privilege to say, we, the government, are in the midst of a investigation involving national security, and we simply cannot be compelled by a court to give you information about the investigation. So from a practical standpoint, a challenge would be very, very difficult.
I see, yeah. In these privacy cases or data breach cases, though this isn't a breach, but it's a situation where records are out there that you may not want to be out there, the biggest issue for anyone looking to challenge or litigate over something like this is that they have to prove quantitative harm to them, and that's a very difficult thing to prove in cases like this.
That's exactly right, and oftentimes the damages for statutes that expressly address breaches of privacy with respect to electronic data have statutory damages, so that when Congress or whatever legislature made that law, they had a vision of being a cause of action for people whose privacy was impinged upon improperly. In this case, that's not provided by the statute that created this court.
I see. This is going to be an interesting story to watch. We've had two NSA scandals break in the past 2 days, so you just don't really know what's around the corner with this. Once again, that was Andrew Hinkes of Berger Singerman. For his full insight on this story, be sure to visit ediscoveryreporter.com, and of course visit us at LXBN.com for curated commentary from the entirety of the Lex Blog Network, all 8,000 members. We have a number of excellent pieces on the NSA scandal this week. Thanks for joining me today, Andrew.
Thank you, Colin.